David Carrick, Police Narcissist Part 3. Hello, I'm H.G. Tudor. I'm continuing my reading of the judge's sentencing remarks to enable you to understand the full detail of David Carrick's behaviour. Whilst part of it makes for unpleasant listening, it does enable you to understand so much about the mindset of this particular narcissist and the way that he behaves. It also demonstrates to you the fact that he utilises dating sites as a hunting ground. And whilst, of course, far be it from all individuals who use dating sites to behave in this manner, it does underpin the danger that is evidenced because they are hunting grounds for our kind. And if you have not already watched my video Why You Should Not Use Online Dating, perhaps listening to this video and the effects of this man's behaviour upon his victims may compel you to have a greater regard to its content. The judge's sentencing remarks continue. You are 48 years old. You are aged between 28 and 45 when you committed the offences for which I have to sentence you. When interviewed about these crimes at various times following arrest, you either denied, first line of the twin lines of the narcissistic defence, denial, any sexual activity or other offending, or asserted that you always acted with the consent of the woman concerned, lie. You pleaded not guilty to all charges when arraigned at hearings between December 2021 and December 2022. You changed your pleas in December 2022 and January this year. Beyond that, you have not expressed remorse, absence of remorse, or regret for what you have done, although you have demonstrated that these proceedings have had a grave impact on you, to which I will come. The criminality you have admitted may be called an unrestrained campaign of rape and abuse of women. It could be described as the work of a serial rapist. But it may not be possible to encapsulate succinctly the broad devastation you have caused through sexual violence and exploitation, all the time carrying the unique and defining office of a police constable. Various guidelines drafted by the Sentencing Council are relevant to individual offences, and some of the overarching guidelines also apply, including the Domestic Abuse Guideline. But it is not necessary for me to set out their contents in detail in these sentencing remarks, because the gravity of all subsidiary offending can be reflected fairly in the overall sentences for rape. Generally, throughout, there is high culpability and greater harm. The guideline for rape provides that sentences above 20 years imprisonment are appropriate for a campaign of rape. The prosecution submits that such sentences would be appropriate in the individual cases of at least 5 of your victims. The maximum sentence is life imprisonment. Apart from the guilty pleas, there is no material mitigation beyond your lack of previous convictions. I have to bear in mind that the total sentence must be just and proportionate, which means in this case that it is not right to simply add together all the sentences likely to have been passed for individual counts and impose the total. This would lead to a wholly disproportionate outcome. The defence have not served or relied on any psychiatric or psychological report on you. In order that the court had an independent professional assessment of you, I ordered a pre-sentence report. You described childhood trauma to the probation officer, which must have affected your personality. Now, of course, this could be the case that it's a lie, but if it is assumed to be the case that he's experienced childhood trauma, this is a lack of control environment which has contributed to the creation of his narcissism. You grew up with parents who drank to excess and neglected you. Lack of control environment. Likely one or more of them was a narcissist, thus passing on the genetic predisposition to Carrick. When they separated, you became the target of abuse by a stepfather in your teens. Like any child, you should have been nurtured and taught moral strength, and you were not. As an adult, you abused alcohol yourself, although you were able and careful not to do so when working. This indicates that you were able to control yourself when you chose to. There is no mental health issue beyond the inevitable depressive impact of custody. A less credible part of your account to the probation officer is your claim that you are unable to recall your acts of sexual violence and degradation towards women. Lie. I have to conclude that this is a minimization, because you are yet unable to face the enormity of the abhorrent acts you did while a serving police officer. The principal aggravating feature common to all the offences I am dealing with is your use and abuse of the role of a police officer. All the victims were aware of your occupation and affected by it. Triangulation. Some you specifically reassured, false compassion, tricked or intimidated, abusing the trust that the public vests in police officers. Furthermore, the sheer number of offences of rape is relevant to assessing overall criminality, and the domestic context in some of the counts represents a violation of the trust and security that normally exists between people in an intimate setting. Other aggravating features of particular offences include A. Repeated violent rapes, including when women are unwell, use of vulnerability against victim, B. Ejaculation, C. False imprisonment to facilitate commission of sexual offences, D. Use of an imitation firearm, a police baton and a whip to assault and threaten, use of threat, triangulation, physical assault, E. Monitoring women through a camera set up in your home, assertion of control, F. Causing women to vomit during sexual violence, G. Exploiting vulnerable women, H. Presence of others, adult or child nearby, I. Isolating women from their families, isolation, J. Deliberate and sustained humiliation, K. When urinating on women, sometimes into their mouths, forcing them to swallow urine, L. Forcing women to swallow semen, M. Transmission of a sexually transmitted disease, N. Offending in drink, O. Threatening to report a victim to immigration authorities. All of those factors demonstrate a sense of entitlement, lack of accountability for his behaviours, and an absence of emotional empathy. The Sentencing Council guideline on reduction in sentence for guilty pleas applies in your case by Section 73 of the Sentencing Code 2020. The court must take into account the stage at which you indicated your intention to plead guilty and the circumstances in which that indication was given. A sliding scale is applied. You denied all the crimes you were interviewed about. Denial. Until the admissions by way of guilty pleas, there was no acknowledgement on your part that the accusations made against you were true and the police and complainants prepared for a trial. The case has been opened by the prosecution on a full facts basis. I would have allowed a reduction of 15% in sentence to allow for your late guilty pleas to the majority of the charges which were entered in December 2022, with a trial date of 6th of February 2023 having been fixed some months earlier. In respect of the earliest charges, those on the separate indictment on which you were arraigned only in December 2022, you indicated swiftly that you did not contest them, except count 7 which has been left on file, and you pleaded guilty in January 2023. I would have allowed 1/3 reduction. In reaching a conclusion on the correct level of credit for your guilty pleas, I have recognised the impact of one particular feature. Between July 2022 and December 2022, you were removed from HMP Belmarsh and detained at the Rampton Secure Hospital. This was because the prison authorities feared you were suffering from severe depression, and after attending court on the 22nd of February, you had made a committed attempt to kill yourself. You had used a razor blade to make deep cuts to your neck, wrist, and groin. Pity play. Suicide attempt. You were taken to hospital by air ambulance, returning to Belmarsh on 28th of February. In defence statements served on your behalf on the 24th of May and 14th of July 2022, you claimed that what the witness complained about was either entirely made up or consensual. Lie. You were removed to Rampton on 22nd of July 2022 for assessment and treatment. Thereafter, your lawyers had limited, if any, contact with you or news about you. It was only after the court intervened seeking an update in your treatment that on the 16th and 18th of November, the consultant psychiatrist responsible for you at Rampton Hospital provided a conclusion. This was that you were not suffering from any mental disorder requiring treatment in hospital, and you will be returned to HMP Belmarsh when arrangements could be made for you to be kept under 24-hour surveillance to protect your life from another attempt at your own hand. Those representing you informed the prosecution and the court swiftly after your return to prison that you would be pleading guilty. In the meantime, the victim T on the separate indictment had come forward, and so the further offences were laid against you. As I have said, you changed your pleas to guilty in January 2023. In all the circumstances, I will allow 20% guilty plea reduction in the notional determinant sentence that would have been appropriate otherwise. I conclude, from all the circumstances and information before me, that you were driven to commit suicide as a self-pitying reaction, judge has it correct, to the shame, he doesn't experience shame, wrought on you by these proceedings rather than from remorse. Essentially, it was a further manipulation carried out by Carrick. The starting point, it is agreed between the parties, is an assessment of dangerousness. Section 308 2, Sentencing Code, introduced by the Sentencing Act 2020, provides that where a court has to assess whether there is a significant risk to members of the public of serious harm occasioned by the commission by the offender of further specified offences, the court, and there's the detail of the statute. It then defines serious harm. I won't go through all of that to save time. I have to consider what form of sentence should follow this determination. Section 285 of the Sentencing Code applies to those offences you committed after the 4th of April 2005, which comprise the majority. I consider that the seriousness of the offences for which I have to sentence you is such as to justify the imposition of a last resort sentence of imprisonment for life. Indeed, only such a sentence will meet the gravity of the offending I have to deal with you, for in combination with the risk you pose. Similarly, for the 5 offences of rape which fall out with the sentencing guide scheme, I am satisfied that life sentences are required to meet the gravity of the offending and the risk you will continue to pose. I have assessed very carefully whether, given your abusive position, this case should attract a whole life order. The rare sentence of last resort is a life sentence with a whole life tariff. In Crown v. McCann, Singer, Sinaga and Shah, the court examined conjoined cases involving serious sexual offending on a scale of extreme gravity. Although life sentences with minimum terms to be served of 40 years were appropriate after a trial, none of those cases reached the threshold for a whole life tariff in the view of the court. None of those offenders was a policeman, and the court did not have drawn to their attention any potential scenario close to the one presented at this court. However, the prosecution specifically does not seek to persuade me that your offending fits the description of wholly exceptional circumstances, which the court indicated would justify such an order. I have also scrutinised the judgment of the court in another recent conjoined case, Crown against Stewart, Cousins, Tustin and Hughes, in which the offender Cousins appealed against the whole life order imposed on him following a notorious abduction of a young woman from the streets of London, accomplished while he was an off-duty police officer by use of his warrant card, followed by her rape and murder. The court accepted that the police officers are in uniquely powerful positions. In respect of fixing of minimum terms where a mandatory life sentence is required by the law, as set out in Schedule 21 of Sentencing Code, a different scheme to the one I have to apply, Lord Burnett CJ, stated the principle. In our view, the correct approach is to focus on the facts which in a rare case might lead to the conclusion that a whole life order is appropriate. This was, as the judge said, warped, selfish and brutal offending, which was both sexual and homicidal. It was a case with unique and extreme aggravating features. Chief amongst these, as the judge correctly identified, was the grotesque misuse by Cousins of his position as a police officer, with all that connoted to facilitate Miss Everard's kidnap, rape and murder. We agree with the observations of the judge about the unique position of the police, the critical importance of their role, and the critical trust that the public repose in them. Had the court in McCann imagined the facts of this case, would they have equated it to the gravity of the near-miss mass murder attempt or the foiled terrorist atrocity, which the court considered would compel a court to attach a whole life tariff to a discretionary life sentence? The standout feature is the element of abuse of the status of a police constable. But having considered the matter with care, I have come to the same conclusion as the prosecution. Of the utmost gravity though this is, the wholly exceptional circumstances test is not met. Thus, the imposition of a discretionary life sentence without a whole life tariff must be accompanied by an evaluation of the notional determinate term that would have been required to mark the gravity of the total offending had a life sentence not been imposed. That term provides the start of the calculation required to reach a minimum term an offender must serve. It must be for the shortest term that is commensurate with the seriousness of the offence before the court. The prosecuting counsel offers the defence counsel offers some mitigation, but the judge doesn't agree with it and states, your offending was over 17 years and encompassed 12 victims. This shows, of course, a sustained period of activity, which demonstrates the threshold of supporting his narcissism. Moreover, the singular element which elevates your offending as a brutal serial rapist into that company is the principal aggravating feature of the explicit or implicit use of your occupation to entice, reassure, or intimidate your victims. I have to bear in mind that my function is to impose appropriate punishment, and when that is served, the parole board will determine how to protect the public thereafter. Decades will have passed before that time comes. I conclude that the notional determinate sentence that would provide a just and proportionate punishment is 60 years. To that, the guilty plea discount of 20% will be applied. It is to your credit that you did not contest a trial. Your decision deserves this recognition because there is no doubt that a court hearing at which evidence is given and challenged provides a particular ordeal for victims. From the resulting term of 48 years, I have to set 2/3 minus the time spent so far in custody, which is 491 days. Stand up, David Carrick. I have made ancillary orders for deprivation pursuant to Section 153 of the Sentencing Act 2020 and restraining orders under Section 359 and 360 of the Act. They will remain in force until further order. The victim surcharge applies. I make no sexual harm prevention orders given the nature of the sentence I am about to pass. On the main indictment of counts 16, 19, 29, 30, 31, 32, 38, 39, 42, and 43. The sentence is 4 years imprisonment on each concurrent. On counts 24 and 25, the sentence is 7 years on each concurrent. On count 6, on the second indictment, I impose a concurrent determinate sentence of 9 years. 31 sentences of life imprisonment are imposed on the main indictment on counts 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 17, 18, 20, 21, 22, 23, 26, 27, 28, 33, 34, 35, 36, 37, 40, and 41. Also, 5 life sentences are imposed on the second indictment on counts 1, 2, 3, 4, and 5. This makes a total of 36 life sentences. The minimum term you will have to serve before the parole board can think of releasing you is 30 years, 239 days. You may go down. The court salutes the courage of all the victims and their families. I hope that they are able to thrive in the rest of their lives. The teams of police officers concerned have worked hard to bring this case to court and keep the confidence of victims. To do so under the fierce scrutiny this case has attracted is promising for the future. The Crown Prosecution Service lawyers and counsel have met tight deadlines set by the court and put the case together fairly and effectively. The defence team has met the challenge of dealing with an evolving set of grave allegations and a completely disorientated client with patient and professionalism. The court wishes to recognise that work and thank all of you. Accordingly, 36 life sentences given to Carrick, and it shows the various behaviours that he indulged in and engaged in that demonstrate that this individual is a narcissist. Time and time again, evidence is demonstrated that supports that he is a narcissist, showing his sense of entitlement, the complete absence of emotional empathy, a lack of accountability, grandiosity, haughty behaviours. It shows the various manipulations that he used, primarily starting off with charm as part of the golden period and swiftly moving to brutal physical and sexual violence. Furthermore, involving humiliation, intimidation, and threat. He showed various aspects of the narcissistic dynamic and a complete absence of boundary recognition. The sentencing remarks were all challenge fuel. He was being spoken about, so they're fuel for him, but they challenged him because of the manner in which the disapproval, to put it mildly, of his conduct and behaviour is expressed. Some of you know that as a consequence of this, this has prompted a review of complaints of domestic violence against police officers, with some 1,000 complaints being located in one place against 45,000 members of the police force. It demonstrates the nature of this individual, whereby, as a consequence of his need for control and to obtain fuel, and the residual benefit of the pleasure that he derived from the way that he treated these individuals and the sexual act itself, that he was driven to pursue the prime aims in a brutal and rudimentary fashion. It is a clear example of a narcissist at work, and a clear example of the various manipulations and aspects of narcissism. I'm H.G. Tudor.